Administrative Tribunal. Administrative Tribunal is that was a Neha Guru Nani written by the article as a student of Guru Gobind Singh University of New Delhi. Okay, so in this article, Administrative Tribunal is a law that is tribunal is used to significant sense of only adjudicatory functions ordinary system. So technically, the judicial power are vested in the courts, aim to safeguard the rights of individual. Therefore, the institution and effective system where the fewer complexities with the judicial power delegated to the administrative authority. If it is delegated, okay, if it is delegated, then giving rights to the tribunal for adjudicatory bodies, and it is a quasi-judicial function. Quasi-judicial features are there. To know the administrative tribunal is referred to as followed. The concept of tribunal came existent with the establishment of the income tax tribunal before independence. After independence, needs was being felt to resolving the disputes, and the core objective was to provide the speedy justice to people. After drafting several rights of welfare of the individual, our constitution, people have the right to speedy trial and a specialized quality which cannot be delivered. So that's why overburdened cases are there. There are overburdened cases. Hence, the need for the administrative tribunal cannot be ignored. So you can see here growth of the administrative tribunal, that was 42 amendment, part 14A and article 323A of the constitution. Tribunal was administrative matters issues, and according to these provisions of the constitution, tribunal are to organize and establish in such a manner do not violate the integrity of the judicial system, and which form the basic structure and the integrity. And under article 323A and B was done, primary objective was the high court. Under article 26 and 227 of Supreme Court, article 136 for the originating the efficacious alternative institution for the judicial cases. So this is the alternative institutional mechanism. The purpose was to the exclusive jurisdiction of High Court was done to reduce the pendencies. Therefore, tribunal are organized the part of civil and criminal court system, and from these functions, every tribunal is a neither an exclusively judicial but nor a absolute administrative, not a judicial and not a administrative body, but somewhere it is of two, between two. That's why administrative tribunal is a quasi judicial body. It is a quasi judicial body. So these characteristics are there. Administrative tribunal must have a statutory organ. First of all, they should have a statutory. Some feature are ordinary court, and administrative tribunal perform the quasi judicial functions bound by the judiciary of they are not adhered by the strict rules. So not adhered by the strict rule. Administrative tribunal independent, not subject to any administrative interference. There is no interference. Okay, and in the procedure, the administrative tribunal possesses the power of court to summon and admit oaths and to compel the production of the document. So summon कर सकते हैं, compel. These tribunals are bound abide by the principle of natural justice. So they are abide by the principle of natural justice, fair, open, impartial act indispensable for the administrative tribunal. The prerogative writs and certiorari prohibition are available against the administrative tribunal also. So what are the categories? You know that administrative tribunal of the service matter. A is providing tribunal made by the parliament. So first of all, act of the parliament, adjudication of the complaints related to recruitment conditions, government of servants, and as a sender in the state. It includes the employee of the local authority, another authority within the territory of India controlled by the government of India, of a corporation owned by the controlled by the government. So establishment of the such tribunal must be at the center and the state level. two or more states. The law must incorporate the provision of the jurisdiction power authority to be exercised by the tribunal, the procedure to be followed by the tribunal, the exclusion of jurisdiction all of the courts except the Supreme Court. So if you need to go for the procedure, then exclusion of the jurisdiction for all other courts except the Supreme Court of India. In Supreme Court of India, you can go there against them. Okay. So tribunal for the matter of B. B में क्या है? Empower the parliament for the state legislature to tribunal adjudications with respect of the matter of this B, and that is levy, assessment, collection, enforcement of the taxes, industrial dispute, labor disputes, supply dispute, regulation of the Tennessee issue, and law must be at jurisdiction power tribunal of the procedure followed. So landmark judgment of Chandra Kumar case of the various conclusion of there was a 323A and 323B, and this court struck down the clause on the excluded jurisdiction of the High Court and Supreme Court under the this. So this ground they are excluded jurisdiction of the High Court, and they are excluded from the High Court, but still they are under the 226, 227 and 32 respectively. Supreme Court ruled that the tribunal created are continued to be court of first instance, and for the continued, the litigant are not allowed to approach to the High Court directly by overlooking the jurisdiction of concerned tribunal. So you are not directly allowed to go to the High Court. No appeal of the decision tribunal would be directly before the Supreme Court under the 136, but instead agreed party would entitled to move High Court under 226 and 227, and after decision division bench of High Court, the party may approach to the apex court. You can also go under Article 136. So this is the provision. In starting you can't go, but if there is any problem, then only you can go for 226, 227 and 136. Okay, now what are the courts and administrative tribunal? So courts, they are law part of the traditional system. Court law vested general jurisdiction, strictly bound by the rule of evidence or procedure of the civil court. So there is a civil procedure code, and it is presided over by the officer expert. The decision of the court is objective and primarily based on the evidences and material produced. It bound by the precedent, the principle of natural justice. This is the natural justice is there, and it can be decide validity of legislation. But the administrative tribunal created by the statute and empowered by the judicial powers are there. It deal with the several matters, and it vested limited jurisdiction decide the issue. It is not bound by the rule of evidence act. एविडेंस एक्ट से ये नहीं बाउंड होते हैं, and are create the tribunal impose such obligation. It is not mandatory in every case that the member need to be trained, so the decision is subjective, and at the time it may be decide the matter taking account of policy and expediency. So it is not obligatory to follow the precedence and principle of the jurisdiction, but principle of natural justice must be followed. Here is the natural justice that is must be followed, and this is also natural justice is followed. It cannot decide the validity of the legislation, it can decide the validity of the legislation. The court do not follow investigation inquisition function rather than decide case basis of evidence, and many tribunal perform the investigation as well as the quasi judicial. So this is the quasi judicial function, but they are not mandatory. Every case of the member need to train the expert law, and the decision subjective होते हैं. ठीक है, this is the objective, but here is the subjective. It may decide the matter taking account the policy of expediency, and it is not bound by the rule of evidence act. So it is very important thing that not bound by the evidence act and CPC, but it is following the natural justice. That is important thing, that it is follow the principle of natural justice. Okay, but it does not obligatory to follow the principle of natural justice, but the principle of natural justice must be followed. Principle of रेस जुडिकेशन लाइक मतलब रेस जुडिकेशन को फॉलो नहीं करना है, लेकिन प्रिंसिपल नेचुरल जस्टिस को यहाँ फॉलो कर रहे हैं. बट यहाँ पे क्या है कि प्रिंसिपल रेस जुडिकेशन एंड प्रिंसिपल नेचुरल जस्टिस ये दोनों से यहाँ पे बोथ है, और यहाँ पे है नेचुरल जस्टिस, बट ये फॉलो नहीं करता है उसको एविडेंस एक्ट को. ठीक है. सो 1983 में ट्रिब्यूनल एक्ट आया था 323A, and that is matter falling according to this central admin tribunal. A state admin tribunal भी every state में होता है. This tribunal declared the constitutionality relevant laws and statute act extend in far as it is related to the central administration to whole of India in relation to the state. It is applicable to the whole India and the Jammu Kashmir also. What are the objectives? To relieve congestion in court, to lower or burden. Like सबसे पहले आपको बर्डन रिड्यूस करना है, प्रोवाइड स्पीडियर जस्टिस सिस्टम. एंड सेक्शन 2 में क्या है? टू मेंबर इज नेवल मिलिट्री सो आर्म फोर्सेस जो आते हैं. सो सेक्शन 2 एक्ट इज अप्लाई द सेंट्रल गवर्नमेंट एक्सेप्ट, मतलब ये सब जगह पर अप्लाई होता है लेकिन नेवल मिलिट्री में अप्लाई नहीं होगा, सुप्रीम कोर्ट हाई कोर्ट में अप्लाई नहीं होगा. ए पर्सन अपॉइंटेड सेक्रेटरीट स्टाफ ऑफ द हाउस ऑफ पार्लियामेंट, एंड हाउस ऑफ पार्लियामेंट के सेक्रेटरीट स्टाफ में भी ये अप्लाई नहीं होगा. ठीक है. देन व्हाट आर द कंपोजिशन? सेक्शन 4. अब ये सेक्शन 2 जो था इसमें बताया गया था कि कहाँ अप्लाई नहीं होगा. देन सेक्शन 4 में कंपोजिशन है. एक्ट डिस्क्राइब द कंपोजिशन ऑफ ट्रिब्यूनल्स. चेयरमैन, वाइस चेयरपर्सन, जुडिशियल एडमिनिस्ट्रेटिव मेंबर. एवरी बेंच मस्ट इंक्लूड एटलीस्ट वन जुडिशियल, वन एडमिनिस्ट्रेटिव बेंच. सेंट्रल ट्रिब्यूनल और न्यू दिल्ली, Allahabad, Calcutta, Madras, Bombay, and this the chairman may transfer the vice chairperson and other member. Qualification: section 6 was like section 4 is for the composition, 2 is for the applicability, and section 6 that is for the qualification and appointment. So to appointed the chairman person must have the judge of high court and office of the vice chairperson as 2 year, held the office of the secretary for the India, held any post carrying out the scale pay of secretary. So this is the person must leave the following qualifications. Okay, next है vice chairperson जो होगा has a judge of high court or supreme court, 2 year post for secretary of the government holding post carrying out the pay scale central, and 5 year post for the additional secretary. 2 साल तो सेक्रेटरी हो, 5 साल तक एडिशनल सेक्रेटरी और जो भी हो. जुडिशियल मेंबर्स ऑल्सो बी और हैव बीन ए जज ऑफ द हाई कोर्ट, हैव बीन ए मेंबर ऑफ इंडियन लीगल सिस्टम. तो जज ऑफ द हाई कोर्ट होना चाहिए, जज ऑफ द हाई कोर्ट और द लीगल सिस्टम में 3 साल तक इसने वर्क किया हो. व्हाट आर द एडमिनिस्ट्रेटिव मैटर? सो हैव हेल्ड द पोस्ट ऑफ एडिशनल सेक्रेटरी ऑफ द 2 ईयर तक, एंड हैव ए जॉइंट सेक्रेटरी का कम काम किया हो, या फिर हैव ए एडिकेट एडमिनिस्ट्रेटिव एक्सपीरियंसेस. चेयरमैन, वाइस चेयरपर्सन एंड अदर मेंबर्स शैल अपॉइंटेड बाय द president will appoint them, and the judicial members shall appointed by the president, consultation of CJI, and the chairman, vice chairperson and other member of the tribunal shall be appointed by the president, consultation of the governor. टर्म क्या होती है? सेक्शन 8 ऑफ द एक्ट ऑफ चेयरपर्सन एंड मेंबर, 65 ईयर फॉर द चेयरमैन एंड द 62 ईयर फॉर द मेंबर्स. ओके, नाउ व्हाट आर सेक्शन 8 के अंतर्गत इसकी टर्म बताई गई है. सेक्शन 9 में कैसे इनको रिमूवल किया जाएगा? सो एक्ट प्रिस्क्राइब द प्रोसीजर ऑफ द रेजिग्नेशन बाय द मेंबर रिमूवल. चेयरपर्सन और वाइस चेयरपर्सन रिजाइन करेंगे प्रेसिडेंट को राइट करके, and shall remove from the office only order of the present ground of prove misbehavior. and अगर किसी ऑफिस ऑफ प्रॉफिट में वर्क कर रहे हैं अगेंस्ट दैट shall be given a reasonable opportunity to hearing also, and central government may make the rules regulation to procedure for the investigation of the charges against them. So this is under the section 9. Section 8 is given the term, and section 9 is given the removal. Section 14 of the tribunal, that is stated that the central tribunal from day to day appointment shall exercise all the jurisdiction. This is like jurisdiction. Okay, this is when within the jurisdiction of other court, like except supreme court में नहीं आना चाहिए. So recruitment of any civil services, all India services, union civilian, and under the union civilian employee of defense service, all the service matters of the also employee of local authorities, and government of India, corporation, society is controlled by the government. All service matters such person have been placed state government, local government, corporation disposal of the central government. So here you can say any corporation of the owned by the government of India is given here, and here is given the all India service under the union civilian of the defense service also. ठीक है. So now procedure and power of the tribunal, that is section 22 Administrative Tribunal Act 1985. Tribunal not bound by the code of civil procedure and but must abide by the natural justice. So this is the abide by the natural justice and the tribunal shall decide the application and cases made it as a rapidly possible decided after scrutinizing the document. Tribunal have the same power of the civil court under the Code of Civil Procedure 1908. They are not bound, but they have the power while trying to suit with regard the following: summon karna, attendance any person, examining the oath and production of the document, receiving evidences, ask for any record of document of section 123 124 of the Indian Evidence Act of 1872, issue the commission the examination witness of the document, review karna, decide the cases, setting of the past any other matter prescribed by central government and leading cases. Now Sampath Kumar case, that was the constant validity of administrative tribunal of 1985, predominantly challenged by the jurisdiction of the High Court, and this with regard to the service matter hence destroyed. Concept of judicial review was essential feature of the Indian. So अगर कोई मैटर है, अगर आपको और ज़्यादा आगे जाना है, so you can go in the 2006 and 227 in the High Court, like you can ground of that act is exclude the jurisdiction of High Court. Judgment 5 bench judges are there in the section 6(1)(c). Court held enough that a jurisdiction of judicial review are there for service matter. It has not entirely excluded the concept of judicial review. Jurisdiction of Supreme Court under 32 and 136 has not been excluded. So thus there still exists an authority where the matter of injustice can be entertained the judicial review. A judicial review which is a part of the basic structure of constitution only if alternative effective institution mechanism are the provided. So now act was unconstitutional as its unrestricted power of the chairman and vice chairperson. So these appointments must made by the government in meaningful and effective manner of the Chief Justice of India. The court recommendations are given. The term is 5 year prescribed under the chairman and vice chairperson. It would act as a dissuasion for the good and generous people. So direction given the Supreme Court through the Administrative Tribunal Act 1987, the constitutionality of National Company Law Tribunal, National Company Law Appellate Tribunal on this follow. So under this Gandhi President Madras, Parliament does not have authority to vest judicial functions. Tribunal have been traditionally performed by the High Court, and transferring the entire company jurisdiction of High Court to the tribunal are violate the doctrine of rule of law, separation of power and independence judiciary also. So if we are transferring the power to jurisdiction to the High Court to the tribunal, then it will violate the rule of law, and the various provision of Company Act are defective and unconstitutional and breach of the constitutional principle of rule of law. That's why what are the judgment? National Company Law Tribunal in the exercising the power High Court subject to necessary changes under the Company Act 1956 amended and 2002. Okay, so the court acknowledged and upheld the constitutional power of the Parliament, constituted tribunal for the disputes and the legislation competence Parliament to provide the creation of the tribunal. 245, 246, 247 of the read the various entire list and no way affected control by the 323A and 323B. The court further added cannot be assumed that constitution tribunal and transferring judicial power as a rule of law, separation of power, and because of enable the court to tribunal exercise the judicial power, and they are exercising judicial power. What are the matter whether they are tribunals respect and maintain principle of separation of power, rule of law, independent judiciary, and subject to judicial review. So court in exercise of judicial review look after the matter of the principle of such tribunals. Okay, so what are the advantage of the tribunal? This is the there is a flexibility, like judicial system जो है which is very rigid, that's why it providing the flexibility, unlike the procedure of ordinary court are the stringent in flexible. So these tribunals are informal and easygoing. Speedy justice are also their procedure have not been complex and matter quickly efficiently you can decide, less expensive, it is a result of the expenses, and that's have a slow going making the litigation very costly, but it is cheaper, and quality justice you can get in a best price and relief from the courts also. What are the drawback of this tribunal? Although the administrative tribunal play a very crucial role for the welfare of modern society, they are against the rule of law. Against the rule of law. Okay, so This rule of law are propounded to promote the equality of the law, but the administrative tribunal somewhat restrict the rule of law, providing the separate laws also. Lack of specific procedure, there is a chance of violation of principle of natural justice. So natural justice, even though they provide, but still they can violate this. And okay, no prediction of the future decisions, and it not possible predict the future. Scope of arbitrariness is also there, like criminal sources are there, but the administrative tribunal have no such stringent procedures, and absence of legal expertise also. That's why what are the conclusion? It concluded that present scenario the administrative have become an important part of the government, and now therefore concept of administrative tribunal was emerged as a dynamically flourishing the flaws and strength. Now there is some laws are there, references are given, so you can see this topic also.